Judge, he brutalized two different women within a matter of months. He assaulted these two different women, threatened them both with a knife, choked both of these women. He could have killed both of these women.
Why should I give you deferred or probation? CR 6212, State of Texas versus Dane Cortez. And are you Dane Cortez?
Yes, ma'am.
All right. You entered a plea on July 25th, 2022. The court found there was sufficient evidence to find you guilty. The court found you guilty. A TAP evaluation and PSI report was done on September 20th. The case was reset due to your attorney's illness. And so now we're here for sentencing. Have both parties had a chance to review the PSI report, State?
We have, Your Honor.
Defense?
We have, Your Honor.
Any objections to the PSI report, State?
No, Your Honor.
Defense?
None, Your Honor.
All right. According to your plea bargaining agreement, Mr. Cortez, punishment is to be assessed at a cap of 10 years in the prison. There's a $1,500 fine. The state is opposing your applications. They're taking in consideration 2021 CR 6392. There's an affirmative finding of family violence and no contact with two parties. State, do you have any witnesses?
No witnesses, Your Honor. Our victim, or one of our victims, could not get a ride this morning, so I just have her victim impact statement to read.
All right. Defense, any witnesses?
None, Your Honor.
All right. Then the court will hear argument. State, you're opposed to the applications. Why?
Judge, he brutalized two different women within a matter of months. He assaulted these two different women, threatened them both with a knife, choked both of these women. He could have killed both of these women, not to mention the fact that he's already got an extensive criminal history that includes both felonies, misdemeanors. He's already been to prison before. He's had he's had several arrests for prior assaultive offenses, and he's been convicted of a prior assault. And he's still not taking responsibility. He still says, oh, I just got a little rough with her. He considers choking these women, threatening these women with knives, beating these women, just getting a little rough. We believe that he's dangerous. He poses a threat to these victims and the community. So we would ask that you hit the cap of 10 years and sentence him to prison.
All right. Defense?
Mr. Cortez wants to avail himself of any kind of rehabilitative assets that the probation department might have. The first three paragraphs of the TAP evaluation are quite compelling. He's had an extensive history of mental illness acting in conjunction with drug abuse and alcoholism. He wants to try to improve. He's asking the court to grant him 10 years of community supervision. And although the TAP evaluation is not a suggestion of the court granting probation, it is a suggestion that if you did, that it be inpatient treatment. I believe that the assets that are available through probation are more rehabilitative in nature. Yes, we do have facilities at the Texas Department of Criminal Justice that will also address his issues. But if you make this the tightest locked down probation possible, if Mr. Cortez fails to comply, he'll go to the Texas Department of Criminal Justice. He'll do his 10 years, but maybe he can benefit, maybe society can benefit from whatever treatment he would get up front through the inpatient program. Is it DDOF? I've got the acronym wrong, Your Honor, but
Okay.
you read it right
Yes.
there.
All right. Anything you wish to say?
Yes, ma'am.
All right. Let me have you raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. Lower your hand. State your name for the record.
Dane Andrew Cortez.
All right. And could you keep your voice up so I can hear what you have to say? What do you have to say?
I just want to first apologize to the victims in these cases and to the courts and my family. I want to say that I do accept responsibility for my actions and I've made some really poor choices. And I want to just ask for a chance of the future to make better choices. And I know like I should have been being a productive member of the community, but I was doing negative things and I was on drugs and I was living wrong and I was always doing the wrong thing. So I do admit that I have done wrong.
All right. Any questions from the defense?
None, Your Honor. I'll rest with his allocution.
Any questions from the state?
No questions. We're just still asking that he be sent to prison for 10 years.
All right. I have a question. Why should I give you deferred or probation?
Because I know I've completed well, Your Honor, and I'm yours.
But why do people need probation or deferred adjudication in order to behave appropriately in society? How old are you?
29.
So I always read everything before I accept a plea, and I always read everything the day of the plea, just so I can refamiliarize myself with the report and make sure that I haven't forgotten anything. And I always read the PSI report. So there are a lot of things going on with you in this PSI report, and both parties said they had no objections to the PSI report. So I have a choking where the complainant says you were upset because she was texting a male. You choked her, made her block the male's number. Then I have this forced prostitution that she's saying happened. So Ms. Paez revealed that you assaulted and choked her while you were in a dating relationship with her, and that you also forced her to commit acts of prostitution. And then we have this whole incident where she says that you choke her. Then she calls her friend to tell her that you choked her. Then you pull out a pocket knife, and that you have her call a friend back and to say that she made it up. I understand that you have drug issues and cocaine issues, but I don't think drug issues and cocaine issues make you assault people. So why are you assaulting people? I mean, that's what I'm trying to figure out.
Your Honor, I definitely have.
I mean,
I know that I need help, and I know that it's not right. And I just went through some losses, and I was sporadic with my behavior, and my mind was everywhere because I had like PTSD from going through certain issues in my past, and sometimes it makes me just over drink, and I won't know what I'm really doing, and then I'll look back at what I did, and I'll be like, "Oh, that isn't right at all." Then I'll explain that to.
all right. Well, I will tell you, Miss Garcia is saying I have no problem with him applying for probation, but Miss Perez is saying that no, she wants you to go to prison. And mind you, I am objectively looking at everything. So I'm not on anybody's side. I'm not on the complainant's side. I'm not on your side. I'm just looking at things objectively and trying to make a determination on what's best for society and best for you. If there's no chance of rehabilitation, then that's an issue. Then you need to go to prison. You understand?
Judge, sorry to interrupt. I think Ms. Garcia actually said, I'm not okay with him applying for probation.
Thank you. That is correct. So Ms. Garcia is not okay with you applying for probation. Ms. Paez doesn't want you to have probation. And those are things that I consider, but it's not something where I say, oh, the complainant says they shouldn't have probation, so you're immediately going to prison. I like to hear everything and see what's going on. But I don't think there's anything that I can do to help you. There are some cases where people should go to prison. And I'm looking at your federal case, and you've already been to federal prison before. And I don't know that you learned anything from that experience, because I do believe that they give you opportunities to rehabilitate there. So I'm going to deny your applications and find you guilty. Would anyone wish to speak to the cap?
The state would, Your Honor. We would ask that you hit the cap in this case and sentence him to 10 years. Although it's being taken into consideration, you have the evidence that was attached to the plea agreement for the other case against Ms. Ella Garcia, where she was brutalized. The officers described all her injuries in detail. She was taken to the hospital. She was also strangled and threatened with a knife. She was assaulted. And then, as the court has before, for the prior criminal history of the defendant, he's already been to prison, didn't learn his lesson. He's been on probation multiple times, has not learned his lesson. He does pose a threat to these victims, and we think 10 years is appropriate given the circumstances of your case.
All right, Mr. Montgomery.
As we often tell juries in their instructions in a punishment phase, we're not to consider how parole will work. But we're not in a jury situation. And I think we all know that with this young man's previous criminal history, the Board of Pardons and Paroles is likely to keep him for a very substantial amount of whatever sentence you should pronounce. Judge, when he comes out, he's going to be on de facto lifetime probation. I mean, not really, but he'll be a habitual if he ever picks up another felony. There's another judge who used to say to me or to my clients, I can't order you to seek treatment once you're released from the prison, but you really need to do it. I think he was sincere in telling you that he wants to change his ways, that he realizes that what he's done is wrong, and that he intends to seek help. I would ask the court to sentence him to 5 years in the prison.
All right. Mr. Cortez, there is a therapeutic community at the prison. Based upon your charges, I don't think that you will be eligible for it, but I'm not 100% certain of that. I cannot demand or force them to place you in the therapeutic community, but if you would like to be considered for that, I can request it. It doesn't extend the length of time you're in prison, but that may be something that can help you change your life. So would you like me to request the therapeutic community?
Yes, ma'am.
All right, then. As previously stated, the court is finding you guilty. There's an affirmative finding of family violence. There's to be no contact with Amber Hernandez, Elia Garcia. Taking consideration 2021 CR 6392. There's a $1,500 fine, time and money run concurrent. You credit for any time served, a request for the therapeutic community, and I'll sentence you to 9 years in prison. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, good luck with you. We can go off the record. All right, here's the thing, Mr. Cortez. I know nobody wants to go to prison. I always tell defense attorneys and I tell prosecutors, you should always visit prisons. You should always visit the jail, because that's where you're sending people. And you need to know what it's like before you just send people there. So I visited several prisons. I visited several jails. And I know that you may feel some sort of way. You know, why didn't the judge give me a chance? But you need to take this opportunity to work on yourself. Don't get into any relationships when you get out of prison, because your life is not over. You still have a chance to better yourself. You're not like me. I have more of my life behind me than in front of me. I'm in the twilight of my life. So you have plenty of time to improve yourself. And when you get out of the prison, don't get in a relationship. And this is what I tell everybody. And people say, Judge, I can't believe you're saying that. Maybe you're belittling things, but I'm not trying to belittle anything. But this is what I've discovered. Get an orchid. Orchids take lots of patience. I don't know why my staff, they want to show love to me by giving me an orchid when they know I have difficulties with those. But I think they're beautiful. When you first get them, the flowers are on bloom. It's beautiful, just like a relationship. When you first get in a relationship, it's beautiful. Every bad habit that somebody has, you don't think of it as a bad habit. You think, oh, that's beautiful. The fact that they won't put the cap back on the toothpaste and they throw their phone. That's so beautiful. But then after a while, it starts nagging you. Same thing with an orchid. You get it, it's beautiful. Then the flowers fall off. And guess what? It takes a while for them to come back. So get an orchid. When the flowers fall off, if those flowers bloom again, you may be ready for a relationship, because they require patience. You understand?
This defendant walked into court hoping the judge would give him probation instead of prison. But after hearing the state's arguments and digging through his criminal history, the judge had some very serious questions. His attorney argued that treatment could give him a chance to turn his life around. But the judge wasn't convinced that another opportunity would actually change anything. Then the courtroom took an even more unexpected turn. The judge denied probation, found him guilty, and ultimately sentenced him to 9 years in prison, while still giving him one final opportunity to seek treatment behind bars. But that's not where this courtroom story ends. Because in the very same session, another defendant faced a completely different situation. So why did one person walk away with strict probation and treatment, while the other was sent to prison? Let's break down exactly what happened.
2026 CR 007209 State versus Jose Mesa. Could I have parties announced for the record?
Yes, Judge. Grand Rapids State. Contravened to accused.
All right, is there an application?
There is.
Probation, there's an application. Counsel, have you received all discovery? Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Mesa, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
I do.
State proceeding as presented.
We are good.
Mr. Mesa, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with harassment of a public servant. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Mesa, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,000 fine to be probated. State recommends deferred adjudication. They're taking in consideration 2026 CC 002683. Did you understand that to be your plea?
Yes, ma'am.
State defense, is that the plea?
That is a plea, Judge. It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
None.
Outside the agreement, the state is recommending their community supervision be for a term of 4 years. There be 100 hours of community service restitution, a TAP evaluation, no contact with the listed address, the DOEP course, MRT, and anger management. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contact.
State any evidence.
Judge, we have state exhibit number 1, including all text. No objections.
All right, did your state you may be excused?
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, we are.
Anything you wish to say on behalf of your client?
No.
All right, so what happened to your hands?
This was after a bad phone call. I hit the wall,
Okay,
and this was I was rough playing my older brother before I got in here.
okay.
Actually,
So Have you ever used any type of drugs? All right, so what was happening on this day? Because the location you went to, they said that they did not know you.
Yeah,
Did you,
I was drunk. Was I got into a real bad argument with my girlfriend. And at the time I thought it was her house, but it wasn't. Yeah,
do you have any children?
no,
How far did you go in school?
not far. Dropped out. It's the 12th grade.
All right. Do you have any family support? I know you mentioned your brother and everything, but mom, dad, anybody to help you?
It's kind of complicated, Judge.
When's the last time you had employment?
Employment. 6 months ago, I was working at Walmart.
Okay. All right, this is what the court is going to do. Court is going to sentence you to 4 years deferred adjudication, regular reporting by Zoom or in person, regular UAs. And I'm going to want the following done in custody. There's going to be a referral to felony drug court. And there's to be a TAP evaluation. We're going to sign that referral today, so felony drug court will be able to see you before the week is out, okay?
Yes, ma'am.
Be completely honest with them about your alcohol and everything else, all right?
Yes, ma'am.
I'm going to want field visits 1 time per month for 4 months, proof of employment within 60 days of release, no employment as a home health care provider or with minors. Take in consideration 2026 CC 002683, 100 hours of community service restitution. I'm going to ask that an hour be deducted for every sober support meeting completed. And I'm going to require sober support meetings 1 time per week. There's to be no contact with and there's to be no possession of firearms. Probation, is there anything else?
Are you still gonna do the community service? Did I miss that?
No, community service is going to be 100 hours of community service restitution. And I am going to deduct 1 hour for every sober support meeting completed. And I'm ordering sober support meetings 1 time per week.
And you've got everything.
All right, thank you. Is there anything else you need from the court to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, if you need something, do not hesitate to let probation know about it, okay? And I'm gonna put in the system, so I'll be sure to check and see that the referral to felony drug court is completed this week, okay?
How long does that take?
The referral? Oh, the referral is going to be signed now, and since it's Monday, they'll probably be able to see him before the week is out. It's
Okay.
quicker than a TAP evaluation.
Okay.
And that brings this courtroom session to a powerful conclusion. In the first case, the judge made it clear that accountability matters, and that simply asking for another chance isn't enough when the court sees a repeated pattern of harmful behavior. The final sentence, 9 years in prison, along with a request for therapeutic treatment. But the second case showed the other side of the judge's decision-making. Instead of prison, the defendant received 4 years of deferred adjudication, strict supervision, community service, and treatment requirements, designed to give him a genuine opportunity to change. The biggest takeaway from both cases is simple. A second chance comes with responsibility. The court can offer treatment and rehabilitation, but the person standing before the judge has to prove they're willing to change. If you enjoyed this courtroom breakdown, make sure to like the video, subscribe, and turn on notifications so you don't miss the next case.